Okay. Principles of exculpation from criminal law, BARBRI commercial outline, page 38. This is section 6. And the first letter under the section is justification. Under certain circumstances, the commission of a prescribed act is viewed by society as justified and hence not appropriate for criminal punishment. Generally, the defendant must raise the issue of justifiable use of force by introducing some evidence more than a scintilla tending to show justification as an affirmative defense. Once she has done this, the state may require the prosecution to prove that the use of force was not justified, or it may impose on the defendant the burden of proving this affirmative defense by a preponderance of the evidence. So maybe I'll just highlight justification as a term. But in prior sections, we've been seeing them separate the burden of proof out into a separate letter. I'm not sure if they're going to be doing that. So if the defendant raises a defense, even if it is very unlikely or doesn't sound correct, insofar as it is, as there is any little amount, scintilla of proof, then the defense deserves to be ruled out as a affirmative defense, which is one that can reduce the punishment of the crime in which he is being tried. So once he or she has done this, the state may require the prosecution, so sometimes it's the prosecution, to prove that the use of force was not justified. Or, so that's one approach. The other approach is that the defendant has the burden of proving this affirmative defense by a preponderance of the evidence. So, self-defense. Non-deadly force and deadly force is how this is divided. And let's see if we can break it down even further. Right of aggressor to use self-defense. So, as a general rule, an individual who is without fault may use such force as she reasonably believes is necessary to protect herself from the imminent use of unlawful force upon herself. See discussion on reasonableness and unlawful force. Infra. So that might be later. There is no duty to retreat before using non-deadly force, even if retreat would result in no further harm to either party. So I suppose if you are using mace, then you really don't have to worry about retreating before using mace. If you're using a knife or you're using a gun, then you should retreat to the extent feasible that you can do it without harm, all the way to your home and inside of your home, before the starting to use deadly force to protect yourself. But B, deadly force. A person may use deadly force in self-defense if she, ruminant I1, is without fault, and ruminant 2 is confronted with unlawful force, and ruminant 3 reasonably believes that she is threatened with imminent death or great bodily harm. Now, 1 without fault is further described as a person who has initiated an assault or provoked the other party will be considered the aggressor, for the sake of defining without fault, because that doesn't really define without fault now, does it? Without fault is the person who the aggressor has approached. 2. Unlawful force. The attacker must be using unlawful force, which, for example, is force that constitutes a crime or a tort. It cannot be lawful force, which would be, say, for instance, your aggressor is a police officer who's completely justified in approaching you. And 3rd, threat of imminent death or great bodily harm. The defendant must reasonably believe that she has faced imminent death or great bodily harm if she does not respond with that deadly force. The danger of harm must be a present one. There is no right to use deadly force if harm is merely threatened at a future time or the attacker has no present ability to carry out that threat. That's a good description. Example, A, who has his arms tied behind his back, says to D, I'm going to kill you. D pulls out a gun and shoots A. No self-defense. Retreat. 4. Must a person retreat as far as possible before using deadly force, comma, if such retreat is possible without a person endangering himself, question mark. For purposes of this examination, the majority rule is that there is no duty to retreat. A person other than the initial aggressor may use deadly force in self-defense even if this could be avoided by retreating. Even in the minority of courts that follow common law rule and impose a duty to retreat, retreat is only sometimes necessary. First, no retreat is necessary unless it can be made in complete safety. Second, no retreat is necessary in several special situations. Ruminant 1, where the attack occurs in one's own home. Ruminant 2, where the attack occurs while the victim is making a lawful arrest. Or Ruminant 3, where the assailant is in the process of robbing the victim. Example, A is standing in a public park feeding the birds. B walks up to A, pulls a knife from his pocket, and as he comes closer to A, says, I'm going to kill you. A pulls a gun from her pocket and shoots B, killing him. Does A have a defense of self-defense? Under the majority rule, the answer would be yes, because A had no duty to retreat before using deadly force as long as the force was necessary to defend herself against imminent attack. Even under the minority approach, the answer might be yes, because even if A was under a general duty to retreat before using deadly force, here it did not appear that such retreat could have been done in complete safety. I really didn't know that for purposes of the examination that retreat wasn't ultimately necessary. I was definitely under the impression that the common law was the law. So in an examination, when you're answering this question or including it in your essay, I would note both the common law and the majority rule. C, right of aggressor to use self-defense. Generally, one who is at fault for starting confrontation has no defense to use force in her own defense during that confrontation. But an aggressor can regain her right to use force in self-defense in 2 ways. That's 1 or 2, withdrawal or retreat, and 2, sudden escalation. So, in withdrawal or retreat, an aggressor who in good faith attempts to remove herself from the fight and communicates to the other person her desire to remove herself regains her right to use force in self-defense. A good example is that you cannot do this unless you take your weapon and disarm yourself of it. If you still have a weapon in your hand, then most likely your withdrawal is deficient. Your retreat always works if you run and say they catch back up with you. You then have a right to use self-defense according to this here. That doesn't say that's not a recourse, but I'm still not so sure unless you've made it very clear indication that you're withdrawing and then retreat if you actually do regain your use of right of force under self-defense. The sudden escalation example. If the victim of the initial aggression suddenly escalates a minor fight into one involving deadly force and does so without giving the aggressor the chance to withdraw or retreat, the aggressor may use deadly force in her own defense. It's a shame we're not given an example there because this is actually very important. Anyhow, defense of others. There are two issues in determining whether a person who has used force to defend another person is criminally liable for her acts. So A discusses the relationship with the person aided. Must there be some special relationship between the defendant and the person in whose defense she acted? The majority rule is no. One may use force in defense of any other person if the other requirements of the defense are met. A few jurisdictions require that a person whom the defendant aided must either have been a member of the defendant's family or the defendant's employee or employer. B. Status of person aided. A defendant has the defense of others only if she reasonably believes that the person she assisted had the legal right to use force in their own defense. If in fact that person had no such legal right, does the defendant still have a defense? The better view is yes, because all that is necessary for the defense is the reasonable appearance of the right to use force. In a minority of jurisdictions, however, the answer is no, because the defendant steps into the shoes of the person she defends and therefore has no defense if that person had no legal right to use force in self-defense. Meaning the person that you're helping was the aggressor in the wrong. Defense of a dwelling 3. A person is justified in the use of non-deadly force in defense of her dwelling when and to the extent that she reasonably believes that such conduct is necessary to prevent or terminate another's unlawful entry into or attack upon her dwelling. Deadly force. One is generally justified in the use of deadly force in two situations: tumultuous entry plus personal danger and felony. 1. Use of deadly force is justifiable where the entry was made or attempted in a riotous, violent, or tumultuous manner, and the person reasonably believes that the use of force is necessary to prevent a personal attack upon herself or another in the dwelling. And B. Felony. Use of deadly force is also justifiable where the person reasonably believes that such force is necessary to prevent the entry into the dwelling by a person who intends to commit a felony in the dwelling. I don't recall reading that from the book, that deadly force was only allowed during these two circumstances. The book seemed to be of the opinion that you can use deadly force in defense of yourself, right, when there is an entry into your dwelling. But what's being said here is that, or what's trying to be established here is that you could have entry into your dwelling without being in personal danger. For instance, someone enters your home but doesn't present personal danger to yourself or anyone in it, in which case you should be using non-deadly force, not deadly force. But that just wasn't well established in the book. So, at any rate, defense of other property. And that's okay, because we're talking about a defense of a dwelling. We're not talking about a defense of a person. That would be self-defense or defense of others. I guess this would be like if some bum on the side of the road enters your house because they want to go to the bathroom in your house, and you're defending your house from being peed upon, then you shouldn't just kill the person. Defense of other property, which is similar. Again, you're not defending a person or yourself, you're defending the property. So non-deadly force. A. Non-deadly force may be used to defend property of one's possession from unlawful interference. In the case of real property, this means entry or trespass. In the case of personal property, this means removal or damage. And the person must reasonably believe that force is needed, and the need to use force must reasonably appear imminent. So that sounds like two elements, right? Reasonably believe that force is needed, and two, the need to use force must reasonably appear imminent. Thus, force may not be used if a request to desist or refrain from the activity would suffice. In addition, the right to is limited to property in one's possession. Force cannot be used to regain possession of a property that he reasonably believes was wrongfully taken unless the person using it is in immediate pursuit of the taker. So you can beat him if he's taken your purse and is running down the street. Deadly force may not be used, but that's not deadly force. Can you shoot him? Let's see. Defense of property alone can never justify the use of deadly force. Him, I guess not. A person may use deadly force if the defense of property generally only in conjunction with another privileged use of force, self-defense, defense of others, or to effectuate an arrest. For instance, what comes to mind is person steals your stroller with your baby in it. Or your car with your baby in it. He's dead. Criminal prevention. Crime prevention. A and B. A. Non-deadly force. Generally, one is privileged to use force to the extent that he reasonably believes is necessary to prevent a felony, riot, or other serious breach of the peace. Although some states, for example California, have extended this to the prevention of any crime. Deadly force. The traditional rule was that deadly force could be used to prevent the commission of any felony, but the modern view is that deadly force may be used only if it appears reasonably necessary to prevent a dangerous felony involving risk to human life. This would include robbery, arson, burglary of a dwelling. And 6, use of force to effectuate arrest. So, by a police officer, A, and by a private person, B. The use of deadly force to apprehend a fleeing felon constitutes a seizure. Never heard the word in this context. The force used to effect a seizure must be reasonable. Deadly force is reasonable only when the felon threatens death or serious bodily harm, and deadly force is necessary to prevent his escape. For purposes of state criminal law, under this rule, a police officer cannot use deadly force to apprehend an unarmed, non-dangerous felon, but an officer may use deadly force to prevent a felon from escaping if the police officer has probable cause to believe that the felon poses a threat of serious bodily harm to the officer or others. What I want to know is if the felon already caused harm, if you can shoot him. So say he shot somebody and threw his weapon away, disposed of it, and as you see him and have a reasonable belief that he already killed somebody, Can you shoot him while he's fleeing? We'll never know. Anyhow, without looking at law cases. And 1, by person acting at direction of a police officer. A police officer may summon a bystander to assist him in making a lawful arrest. The bystander has the same authority as the officer to use force in making the arrest, and the bystander's good faith assistance is justified even if it later turns out that the officer was exceeding his authority. Did we determine this as deadly force? Yeah, deadly force, deadly force. So, there's been a bank robbery and you're all being held hostage. And we're in a hostage situation and the officer says, you there, kill him with that. And you do. You have a defense to homicide. By private person. A private person has the same right to use force to make an arrest as a police officer or one acting at the direction of a police officer, except that the private person has a defense to the use of deadly force only if the person harmed was actually guilty of the offense, i.e. felony, for which the arrest was made. It is not enough that it reasonably appeared that the person was guilty. A private person has a privilege to use non-deadly force to make an arrest if a crime was in fact committed and the private person has reasonable grounds to believe the person arrested has in fact committed the crime. A private person has the same right to use force to make an arrest as a police officer or one acting at the direction of a police officer, except that the private person has a defense to the use of deadly force only if the person harmed was actually guilty of the offense for which the arrest was made. It is not enough that it reasonably appeared that the person was guilty. A private person has a privilege to use non-deadly force to make an arrest if a crime was in fact committed and the private person has reasonable grounds to believe the person arrested has in fact committed the crime. So, again, hostage situation on a plane. If you don't know yet if the person holding it hostage will use deadly force and kill somebody, once you see that he has with your own eyes, you can pop him off. Resisting arrest. Right to resist person not known to be a police officer. An individual may lawfully repel with deadly force if necessary an attack made by a police officer trying to arrest her if the individual does not know that the person is a police officer. Yeah, because you're like, why are you chasing me, man? Right to resist known police officer. May a person resist arrest if the person attempting to make the arrest is known to be a police officer. The majority rule is that non-deadly force may be used to resist an improper arrest, even if a known officer is making the arrest. A minority of courts and the MPC take the position that force may not be used to resist one known to be a police officer. 8. Necessity. Conduct otherwise criminal is justifiable if the defendant reasonably believed that the conduct was necessary to avoid some harm to society that would exceed the harm caused by the conduct. The test is objective. A good faith belief in the necessity of one's conduct is insufficient. However, causing the death of another to protect property is never justified. So, example. Throwing cargo overboard during a violent storm, if necessary to save the lives of the crew and other people on board a ship, would not constitute criminal damage to property. On the other hand, throwing some members of the crew overboard to save the cargo would never be justifiable. The defense of necessity is not available if the defendant is at fault in creating a situation requiring her to choose between two evils. Finally, under the traditional common law view, the pressure producing the choice of two evils had to come from natural forces. However, modern cases do not require that the necessity arise from natural forces. So, since it hasn't been said yet, I'm going to say it now, that if you're told, and I guess it will be said in the compulsion or coercion section, but if you're asked to choose between two evils being the life of yourself, well, I'm sorry, if you're asked to kill somebody and you cannot avoid this and you do not put yourself in the position that this would have reasonably happen, then your choice of two evils would be to kill yourself or let yourself be killed than to kill somebody else for someone else. You actually don't have the defense to kill someone else to save yourself. So chivalry isn't completely dead because that's still the law. Did I read domestic authority yet? Or public policy? Public policy. A police officer or one assisting her is justified in using reasonable force against another or taking property provided the officer acts pursuant to a law, court order, or process requiring or authorizing her to so act. Example. A public executioner is not guilty of murder when she carries out a lawfully imposed sentence of execution. If the sentence was not lawful, the executioner is still immunized from criminal liability by a reasonable belief that her conduct was required by law. And domestic authority. The parents of a minor child or any person in loco parentis with respect to that child may lawfully use reasonable force upon the child for the purpose of promoting the child's welfare. Whether or not the force is reasonable is judged by the totality of the circumstances, including the age, sex, and health of the child. So you probably shouldn't beat your kid if they have a disorder that could lead to their death. Now we've gotten to the section called excuse of duress, also called compulsion or coercion. A person is not guilty of an offense other than homicide if he performs an otherwise criminal act under the threat of imminent infliction of death or great bodily harm, provided that he reasonably believes death or great bodily harm will be inflicted on himself or on a member of his immediate family if he does not perform such conduct. Threats to harm any third person may also suffice to establish the defense of duress. Traditionally, threats to property were not sufficient. However, a number of states, consistent with the model penal code, do allow for threats to property to give rise to a duress defense, assuming that the value of the property outweighs the harm done to society by commission of the crime. So, somebody threatens to hurt my dog, and in my opinion, the killing of the person who's threatened to do that outweighs the harm done to society by offing that person. Not that an act committed under duress is termed excusable rather than unjustifiable. The subtle distinction stems from the fact that criminal acts performed under duress are condoned by society rather than encouraged. Page 43. Necessity distinguished. Unlike necessity, duress always involves a human threat. A points a gun at B and threatens to kill B if she does not break into C's house and steal food. B does as she is told. B may raise the defense of duress. If, however, B is a starving victim of a plane crash in a desolate area and commits the same act, she has the defense of necessity. Other defenses. Mistake must negate a state of mind. Ignorance or mistake as the matter of fact will affect criminal guilt only if it shows that the defendant did not have the state of mind required for the crime. Example. A, hunting in the woods, shoots at what he reasonably believes to be a deer. In fact, it is B who is killed. A's mistake of fact establishes that he did not have the state of mind required for murder. Was he not wearing his glasses? Right? Compare. A, in the woods, shoots to the trees at a figure he believes to be his enemy. B, intending to kill him. In fact, the figure is C, who is killed. A is guilty for murdering C despite his mistake of fact as to C's identity, because A's mistake does not negate his intent to kill a person. And not a deer. Where are we now? B, requirement that mistake be reasonable. So, 1. Malice and general intent crimes, reasonableness required. If the mistake or ignorance is offered to negate the existence of general intent or malice, it must be a reasonable mistake or ignorance. For example, the type of mistake or ignorance that a reasonable person would have made under the circumstances. 2. Specific intent crimes, reasonableness not required. Any mistake of fact, reasonable or unreasonable, is a defense to a specific intent crime. Example A, leaving a restaurant, takes an umbrella, believing that it was the one she had left there a week ago. In fact, it belongs to B. Is A guilty of larceny? Held? No. Since A believed the umbrella was hers, she could not have intended to deprive B of his right to it. Therefore, she lacked the state of mind necessary for larceny. Since it negates a specific intent, it is not material whether it was a reasonable mistake or not. So this brings up the claim of right defense, is what it's called. So if you're taking something that you think is yours, you're not actually criminal because you don't have a specific intent to deprive somebody of something if you believe it to be yours. So that is termed claim of right. Strict liability crimes, mistake is no defense. Since strict liability crimes require no state of mind, mistake or ignorance of fact is no defense to them. Mistake or ignorance of law, which is kind of complicated. Let's take a break.